Ladies and gentlemen, it is a true pleasure for me to speak during this side event on Grief of Children in Search for Justice, organized by the Association for Defending Victims of Terrorism during the 14th session of the United Nations Human Rights Council. Thank you very much for inviting me. In the region of South Asia, one of the most militarized parts of the world, children have often found themselves on the crossroads of interethnic conflicts, terrorism, radicalization, and extremist violence, easily becoming a target of militant extremist groups for the purposes of exploitation and forced recruitment as child soldiers. Child victims of terrorism often carry certain major features, such as poverty, young age, limited education, lack of work opportunities, lack of family support, history of previous abuse, mental health issues, and living in vulnerable and high-crime areas. Terrorist groups in general terms target helpless individuals who live in unstable regions. Therefore, war-torn states such as Afghanistan, Pakistan, and the region of Jammu and Kashmir create the favorable conditions where thousands of displaced persons become perfect prey once they already lack safe and secure shelter, reliable guardians, and opportunities for positive development. In Afghanistan, the Taliban increasingly use madrasas to provide military training to children between the ages of 13 and 17 in order to deploy them in various military operations. Madrasas serve the Taliban not only through religiously indoctrinating the students there, but also through offering combat training. In an analysis of the profiles of suicide bombers who have struck in Punjab, Pakistan, and likewise the recent suicide terrorist attack in Pulwama in Indian-administered Jammu and Kashmir by Jaish-e-Mohammed terrorist organization based in Pakistan, the law enforcement has reported that more than two-thirds of them has also attended madrasas. Not only children have suffered disproportionately in military conflicts, they've also been used for carrying out insurgent activities like fighting, espionage, and blowing up improvised explosive devices. One of the most chilling factors is the increasing number of child suicide bombers. Children are recruited simply for being children, easily influenced in the righteousness of jihad and less likely to arouse suspicion. Despite the fact that there is no concrete number of how many children are recruited and are currently fighting in Afghanistan, the UN Task Force gives out estimates for the period between September 2010 and December 2014 of 560 children involved as combatants. In addition, the number of verified cases of recruitment and use of children more than doubled compared to 2014 and reached its highest number ever recorded. In 2015, the Ministry of Justice of Afghanistan reported that 214 boys had been detained in juvenile rehabilitation centers on charges connected to threat to national security, including association with armed groups. Moreover, 1 in every 4 civilian casualties in 2015 was a child. Yet, the UN highlights that underreporting remains an issue of grave concern. Another obstacle alongside the deficiency of any appropriate legal tools criminalizing the recruitment and use of children is the absence of rehabilitation programs, which would address the psychological, physical, emotional, and educational state of those who have fought or have been trained in armed groups. In the last few decades, the international community has created numerous legal instruments in order to protect and enforce the rights of children. These conventions provide an international legal framework that prohibits the use of violence against children, as well as outlaws the recruitment of children by state and non-state actors. One legal instrument that recognizes the recruitment processes of terrorist groups is the Hague Marrakesh Memorandum on Good Practices for a More Effective Response to the Foreign Terrorist Fighters, adopted in 2014. It explores the phenomena of individuals who travel abroad to a country other than their country of residence or nationality to engage in, undertake, plan, prepare, carry out, or otherwise support terrorist activity, or to provide or receive terrorist training to do so. It further touches upon the impact of foreign terrorist fighters on providing strategic expertise and financial aid, alongside with facilitating the influx of recruits and arms and promoting violence back to their state of origin. However, its obvious shortcoming is that this memorandum simply lays out a set of good practices that address the process of radicalization to violent extremism, recruitment and facilitation, travel and fighting, and return and reintegration without having any binding power to secure their implementation and regulation in the countries where these issues occur. There is no obligation to adopt these strategies since, according to the memorandum, any legal actions are based on the sovereign decision of each country according to its legal system, priorities, needs, and circumstances. Another instrument that appears more legally binding under the framework of international humanitarian law, and it was mentioned earlier, is the International Criminal Court's child soldier provision. It prohibits the recruitment or use of children under 15 by parties to a conflict. As mentioned, conscripting or enlisting children under the age of 15 years into armed forces or groups, or using them to participate actively in hostilities, is considered a war crime under the Rome Statute of the International Criminal Court, to which Afghanistan is a state party, yet neither Pakistan nor India has signed. Those who commit, order, assist, or have command responsibility for war crimes are subject to prosecution by the ICC or national courts. What though becomes problematic is the 3-year perpetrator-victim gap created by the Rome Statute that renders this demographic group invisible at the ICC. Soldiers older than 15 are not considered child soldiers in terms of being the subject of the crimes enlisted in the provision, and are therefore also not recognized as victims in front of the ICC. At the same time, combatants aged between 15 and 17 fall outside of the prosecutor's jurisdictional reach, since Article 26 of the Rome Statute prohibits the prosecutor from investigating and prosecuting individuals who commit crimes when they are under the age of 18. The outcome is a legal vacuum where a 17-year-old soldier becomes neither a victim nor a perpetrator of war crimes. This statutory gap provides a dangerous legal outlet where armed groups recruit and use individuals between the ages of 15 and 18 because they become technically legally invisible before the court, which in return makes their activities neutral in front of the ICC. Fortunately, recognizing such cracks in the legal framework, the UN adopted and opened for signature, ratification, and accession the optional protocol to the Convention on the Rights of the Child on the Involvement of Children in Armed Conflict, which Afghanistan ratified in 2003. According to it, it is forbidden for non-state military groups to recruit or use in hostilities individuals under 18 years of age under any circumstances. The optional protocol also places obligations on governments to take all feasible measures to prevent such recruitment and use, including the adoption of legal measures necessary to prohibit and criminalize such practices. Military forces and governments also have an obligation to ensure the protection and care of children who are affected by armed conflict. However, these legal provisions address only fait accompli situations where individuals have been long-time radicalized and have been involved in direct terrorist fighting as part of an armed group. The difference with the protocol to prevent, suppress, and punish trafficking in persons, supplementing the United Nations Convention Against Transnational Organized Crime, for example, is that the intention to commit an offense of human trafficking or incite someone to commit an offense are also considered punishable by law. The offense is drawn widely enough to encompass any offense committed by aiding, abetting, counseling, or procuring an offense of trafficking. The leap between radicalization and actual engagement in terrorism is vast. Yet, without attempting to find a solution and deal with the former, all strategies applied to the latter will be futile. Efforts must be concentrating on intercepting and seizing the link while it is still a fetus. Lastly, I just want to finish by stating that the European Foundation for South Asian Studies condemns the victimization of any human being, especially children, anywhere by anyone. Thank you.
Okay, thank you very much.